Hey everybody, it's Paul Yokobitis from Cary Estate Planning, back with another video as part of our 2020 challenge. And today I want to talk about trustee compensation and how that would generally work, whether you're serving as trustee under a will, under a trust, or if you're thinking about appointing a trustee in one of your documents, how they're to be compensated, right? How they may or may not be compensated. So first and foremost, when we're drafting these sorts of documents, we're able to really tailor whatever your intentions are into those documents. So if you want to cap compensation, we could do that. If you want to leave it as, what would generally be found reasonable compensation, it sort of leaves it more up to the trustee to decide or set their own rate. There are some statutory defaults as to, amounts of compensation that can be appropriate without court approval. And they're usually based on a percentage of the assets under trust. Some corporate trustees will preset their rates ahead of time while you're alive, and they usually fall somewhere in the 1% range, which would be assets under trust being managed and only when they are serving. But if you're serving as trustee and if you were a sibling or child or relative of the person who created the trust or the testamentary trust under will, you end up having some flexibility and discretion as to setting what would be appropriate for a reasonable rate of compensation. And sometimes that's going to be an annual percentage, and sometimes that will be an hourly rate or some hybrid combination of the two, maybe an hourly rate up to a certain amount that may equal a percentage, something like that. So usually though, trustees are entitled to compensation because being a trustee is not a light task. It's not easy. It can be easier than some other matters, but it generally carries with it some liability. It carries with it, recurring and important duties that shouldn't be taken lightly. And with that, that's why we do compensation, right? Now, the compensation that's received is considered earned income. So it has to be claimed as taxable earned income by the trustee in the year that they receive it. But generally, we sometimes see, anything from $50 to $250 an hour, depending on who's actually serving as trustee. CPAs and lawyers, when they act in those responsibilities or in those roles, they usually will charge a higher rate, more akin to what they're normally charging for their own hourly rate. Siblings, kids, relatives usually charge a lower amount because obviously they don't have the same, level of experience or expertise. But what that looks like, it can be all over the place. So there isn't a bright line silver bullet rule. It really depends first and foremost on the compensation enabling clause within the document itself, whether there's a cap or not. And obviously, if you are the one creating that type of instrument, you have the opportunity to place a cap or to set forth the sorts of provisions or guidelines as to what compensation could look like. So keeping that in mind, when we're appointing a trustee to serve for instance, for kids, to make sure that things are taken care of into adulthood, you may want to preserve as much principal of the trust as possible, and you may not want, excessive, or what you would believe rather is excessive compensation to reduce the principal value of the trust. So it's important to evaluate these different nuances of how these types of plans will actually carry out, and plan accordingly while you're here and well and are able to effectuate your intentions. If you're interested in looking into trust-based planning and how that may help your estate succession strategy, you can click the link below to get on our calendar. We can discuss what a strategy would look like for you. This is Paul from Cary Estate Planning.